Hi everyone, welcome. Thank you very much for joining us. We've had a huge turnout this morning for our Planning and Infrastructure Bill webinar. It's great to have you all here. Thank you so much for coming. So we have three speakers today. Myself, Penny Simpson, I lead the environment team at Freeths. We have Richard Broadbent, a director in the environment team who works very closely with me and I with him. And we'll be talking about, the two of us, about the nature aspects of the Planning and Infrastructure Bill. And then we have Robert Bruce, one of our leading planning lawyers in our London office, talking about some wider aspects of the bill. So Richard and I will go first, and then Robert. We also have Katie Proctor, who's a legal assistant working with me in Sheffield, and she'll be fielding questions and putting those questions to us at the end of the session. We'll have about 10 minutes, hopefully, of question time at the end of the session. So we're going to kick off with, just wanted to mention our team, of course. We have a significantly enhanced and larger team than you might imagine at Freeths. We have all these people here on this picture are those involved in the leadership of our planning and environment group. We have a team of 40 in total, lawyers and others in the team, and we cover planning law, environmental law, and planning advocacy and planning consultancy. So any planning environment needs you have, we're here for you. Okay, Richard, you're going to start off with an overview of part 3.
Absolutely. So hello, everyone. It's such a pleasure to be talking to you all this morning about this bill. So what we're going to do is give you an overview of how the procedures under part 3 of the bill will operate. So we'll go through that step by step with you, so you have an overview of that. And then what Penny and I are going to do is analyze those stages in a discussion. And we're going to do that on three big themes. And then, as we mentioned just now, Robert's going to take us through the other wider aspects of the bill. So a couple of weeks ago, Penny and I gave a webinar on the government's planning reform working paper on development and nature recovery. That was published on the 15th of December, just before Christmas. And during that webinar, we questioned whether the proposed reforms were in fact appropriate or needed, or whether other measures could be taken under existing laws to address the problems that the working paper is trying to address. And the primary one was nutrient neutrality. Well, we now have the Planning and Infrastructure Bill 2025 and part 3 of that, where the government has set out how it's going to make those changes which were heralded in the working paper. And really, this government, the Labour Party's reputation on the environment will live or die on how these reforms are implemented in practice. This is the most significant change to nature law in England in decades, and I think that's why there's such a big interest in this webinar today. It really is quite important that the changes which are being proposed here. And of course, what we'll ask here is, having change, will that lead to a better system? Will that lead for a better system for the environment, for developers, and for the government and Natural England and its ambitions for nature recovery? Those are the three sort of themes which we'll be discussing later when we've given you this overview of the bill. So let's look at the bill in a bit more detail then. So published just last week, sponsored by MHCLG, Ministry for Housing, Communities and Local Government. And what we have here is the bare bones in primary legislation for a new approach, and that'll be supplemented in due course by secondary legislation and by guidance. But in essence, in a nutshell, what it is a new Natural England-led system for identifying and addressing environmental impacts in England on certain environmental features. And what are those? Well, those are European sites and Ramsar sites. So European sites created under the Habitats Directive, under the Habitats regulations, which transpose that directive into English law. And Ramsar sites, those are sites created pursuant to the Ramsar Treaty on wetlands. So European sites of special scientific interest, those are our own domestically protected sites created under the Wildlife and Countryside Act, and then also protected species. And that includes the European protected species protected under the Habitats Directive and Habitats regulations, so great crested newts, for example, bats, badgers, protected under the Badgers Act, and then wild birds, reptiles, water voles, and other nationally protected species under the Wildlife and Countryside Act. So those are the environmental features which this bill is addressing. Note, please, it doesn't refer to biodiversity net gain. There was speculation a couple of weeks ago that this may extend to biodiversity net gain, which has only been going in its mandatory form for just over a year now. This doesn't. The focus of this is on protected sites and dealing with impacts on protected sites, so diffuse water pollution and nutrient neutrality, for example, or recreational impacts on protected sites, and then protected species, so great crested newts, bats, and all those other things we've been hearing in the news recently. So we have here a system with a new approach for specific developments which will be covered by this associated with development. And under this, the developer will pay a nature restoration levy, so it's a tax on development, into a nature restoration fund. And they'll do that prior to the commencement of development. And then Natural England will use that money to decide what to do with this. That's an opt-in scheme, unless they are compelled to do that using powers to be given to Natural England under the bill. Doing this means that by paying into this nature restoration fund, the impacts associated with the development which are covered by these plans will cut through existing legislation. So cut through existing legislation for protected sites, European protected sites and nationally protected sites, and also the protections for species. So instead of getting your own license, you can rely on a license issued, granted on terms agreed by Natural England under these plans. So what we're going to do now is talk about how this will operate. There's sort of 7 stages to this, and Penny's going to talk you through those now.
Thanks, Richard. Okay, so the first stage to get this system going is for Natural England, either of its own volition or through direction from the Secretary of State, to produce its environmental delivery plan. Now, there may be a number of plans. We can expect in due course there will be a number of plans. Each plan needs to specify the specific development, the maximum development that it relates to. Okay, so it has to identify the development that it relates to, which could be in a large area of the country, or it could be in pockets, different pieces of land around an area, or it could even be one large infrastructure project. So there is enormous flexibility as to what this development plan might focus on in terms of the area and the development, but that has to be specified. Then what happens is Natural England has to identify the environmental features which will be affected by that development and therefore covered by the plan. So it's a modular-based system, so you can expect the plan to talk about the development in a specific area affecting a particular environmental feature. And in the end, the charges that need to be paid for by developers is on a feature-by-feature basis. So they identify the features likely to be affected, then they provide a baseline conservation status for each of those features, and that is a baseline taken at the start of the environmental delivery plan. And then they look at what are the environmental impacts of the development in that area, which is covered by the plan, and that includes it's not necessarily a full assessment of impacts, it's more the impact mechanisms. Once they've done that, Natural England has to then propose the conservation measures which it will deliver or engage others to deliver to address the impacts. So there are 2 things that these measures must do, and it's important that you realise there are 2 things. So this is the indented bullet points on the slide. So first of all, the conservation measures must address the environmental impact of the development on that environmental feature. So that's making sure that there is an offsetting of the impacts. But then also the measures must contribute to an overall improvement in the conservation status of the feature. Now, I think it's fair to say that the focus should be on the word contribute to, because I don't think you can honestly say that this bill and the way it's drafted will definitely lead to an overall improvement in conservation status. So I think contribution is the word to focus on there. The conservation measures could include other extra measures which are there in reserve if the principal measures don't deliver what's needed. That's an option for Natural England to include. Then Natural England must set out the charges, the levy which developers will pay for each environmental feature covered by that environmental development plan. So there might be a specific charge for dormice, a specific charge for a qualifying bird feature of an SPA, or a specific qualifying, specific levy for a qualifying habitat of a European site, for example. So there will be different charges for different environmental features. If a protected species are covered, it will also set out the terms of the license, which is treated as having been granted. This is an interesting concept. We're not entirely sure what this means, but essentially a license will be deemed or treated to have been granted to developers who pay the levy. And then it will have to monitor the effects of the EDP. What happens after Natural England has drafted this plan is that it goes to, they consult on it, that's stage 2, then it goes to the Secretary of State, and that person has to decide whether they're going to make and publish the plan. Now, this is the absolute nub of the standard that's being set. So the Secretary of State has to apply what the legislation calls the overall improvement test. However, I think that's an overstatement. I think what it really is a likely outweighing of development impacts test. So this isn't actually delivering absolutely, definitely an overall improvement. The test, when you read in the legislation, when you read it set out properly, it's the sentence that I've quoted underneath this bit here. Are the conservation measures likely to be sufficient to outweigh the development impacts on that feature? So it's really about the Secretary of State thinking, is this plan likely to outweigh the development impacts? Now, that is not quite the same as a definite overall improvement. Developers then pay the nature restoration levies if they want to opt in, and assuming that Natural England doesn't mandate the plan, and then Natural England delivers the conservation measures or engages others to do that. And then finally, they must report on delivery every 5 years, unless they choose to report more often, and then they may also amend or revoke the plan. So those are the steps to come onto it.
Yeah.
Richard's going to take us through a diagram that he's put together, which I think is really helpful.
Yeah, well, it just helps to visualize this, because that's quite a complicated process and it's new. Okay, so let's try and visualize that and make sense of it. And it's complicated in that it produces a two-tier approach. And so what do we mean by that? Well, let's flush that out by reference to this little diagram that we've got here. So here's Natural England, and they put together the environmental delivery plan using those steps which Penny has just outlined. Okay, so they're preparing that, they're consulting on it, they're gathering the information necessary for it, and so on. Then they put that to the Secretary of State. I'm assuming here that's going to be MHCLG, and the Secretary of State will decide whether to sign that off or not. If they do, then this environmental delivery plan is made and it's published. Okay, so what does that mean in practice? Well, there's two options here. One option is for developers with environmental impacts which are covered by an EDP. So where their particular development has, say, a nutrient impact, and that's covered by the EDP that's just being published for that particular area. The second option, of course, is for developers who are not covered by an EDP. So everyone else in those areas not covered by one of these plans, what is the situation for them? All right, so let's now focus in on the developers which are covered. Okay, so if they're covered, then they have a decision. They can either opt into this new approach, opt into the environmental delivery plan approach, or they can decide to opt out of it. Unless, of course, Natural England exercises its new power where it mandates the developers to pay into this nature restoration fund. So let's assume in this scenario that we're opting in, or Natural England has made it mandatory. So you're paying into a fund, but of course, that's only going to cover those impacts associated with your development which are covered by the plan. It doesn't cover all of your impacts. So for example, if you're having an impact on a particular bat species, but there's another species, so great-crested newts, for example, say the plan covers bats, but not great-crested newts, say they need to watch out for that. Okay, so you pay your money, and you pay your money into this new piggy bank called the Nature Restoration Fund, which is then used by Natural England to deliver the conservation measures set out under that delivery plan. Or Natural England could decide to pay someone else to deliver those conservation measures on their behalf. And presumably that would include landowners, it would include ENGOs, it would include people working with money from other sources already on nature recovery schemes, and this is supplementing that, for example. But there'll be a decision by Natural England as to how to spend the money that comes out of this nature restoration fund. All right, what if I don't opt into this approach, or it hasn't been made mandatory for me? What's my situation then? Okay, so if I am opting out, then I'm going to need to deal with the impact associated with that development. So if, for example, that's nutrients, I'm going to have to go to the market and purchase nutrient credits from landowners, from other actors in the marketplace for that. I need to buy my nutrient credits for my own development to unlock that development. Or if I'm having a species impact, I'm going to need to go and get my own protected species license. That's the normal rules apply in a normal way in that situation. Alternatively, going back to option 2 here, if I am not covered by an environmental delivery plan, well, then it's the same rules that apply currently. I have to go and deal with my particular impacts or get my own license in the normal way. So you have the current rules, the current case law, the current legislation applying for people, as well as a new approach now covered by these delivery plans, and that creates this sort of 2-tier approach that we were talking about earlier. Okay, all right.
That's
so
brilliant,
that
Richard.
yeah. So that's giving you hopefully a good overview of what's in the bill and the different stages associated with that. And what Penny and I are going to do now is analyze the pros and cons of this against those 3 issues, the environment, developers, and Natural England that I described earlier. And look, these are really important reforms, and we get, this is an important moment in environmental law, the development of environmental law. This is clearly an important part of what the government's proposing to do here. And so what we're going to do is give the pros and cons. Okay, we want to give the best arguments for and the best arguments against this approach. Okay, so the first one we're going to look at here is the environment. Does this work for the environment? That's obviously going to be a big question here. So what's our view on that? Well, potentially, yes, it's positive for the environment, but subject to a number of concerns, which we will raise as we go through this. Okay, so let's drill down into what that means. All right, so we'll have a nature restoration fund, and that's going to give Natural England money to do things. And we have a bill that's going to give them additional powers, more tools in the toolbox. In fact, I attended the SIEM Spring Conference yesterday, and Tony gave the keynote at the start of that. And he was
Tony Juniper, yeah.
Tony Juniper, the chair of Natural England,
Yeah.
Gave his keynote at the start, and he was talking about the bill. And he was saying, hey, look, this is going to give us more tools to do things at a landscape scale, nature recovery at a landscape scale. And so there is a sense of optimism about that. So that's going to be, money that's going to be put into schemes, the new compulsory purchase powers, a new duty on other public bodies to cooperate with Natural England in this regard. And that's going to achieve things like catchment level approaches for dealing with nutrients. So for example, at the moment, each development buys its nutrient credits. That's offsetting the impacts associated with development. That's what it's designed to do. But of course, that's not going towards nature recovery. Well, here you could use the funds and the powers under the bill to push farming back from the river's edge, to create that buffer to prevent runoff into the river of diffuse pollution, or to improve the soil ecology so that water is retained on site. Schemes like that could be implemented under this approach.
It's not to say that these schemes couldn't be delivered on a market basis as well, but it's just
exactly right.
It is a possibility that larger schemes may come forward under this new system. And I mean, a couple of other really important things are the fact that the bill talks about putting Ramsar sites on a statutory footing, which is the first time we've seen that. Now, obviously, Ramsar sites have been protected under policy before, so you might argue that that is a positive. Also, we think that SSSIs, you could argue, are being dealt with are potentially being protected more in a better way through the bill, because they now get protection under the statutory footing of the bill. Currently, SSSIs get protection through a process only and through policy, but they're not actually protected. There's no requirement in law for developers to offset their
Well,
impact.
that's a really good point. So, for example, right now for triple SIs, if a decision's being made as to whether to permit operations which may damage the triple SIs, there's a procedure under Section 28I of the Wildlife and Countryside Act that needs to be followed. But you can, at the end of that process, damage the triple SI. Of course, that's subject to what's in national planning policy, but that's what the law says. But here, of course, this likely outweigh test that you described earlier, Penny, well, that applies here in the context of triple SIs, and that's important for triple SIs which aren't European sites. Now, what we're trading that for triple SIs which are European sites and for sites is what we currently have is a process whereby there's a space for the science where there's an appropriate assessment that's carried out as to onto the likely significant effects associated with the development. And then the view is taken through that scientific process as to whether there will be an adverse effect on integrity. If an adverse effect on integrity can't be ruled out, then a political decision can be then made as to whether to proceed with the derogations of imperative reason of overriding public interest or no alternative solutions, and then you can derogate and compensate. What we have here, what we're trading that for, and this is why it's quite a big paradigm shift in the law here, is you're having a new approach where all of that gets smushed in together, and you have a view on the impacts and a political decision as to likely outweighing within the environmental delivery plan. That's what seems to be happening here, and a sort of a loss of distinction over that mitigation hierarchy and how it applies and how those derogation tests apply.
Yeah, and I think I think it's on the European sites that many people have some concerns, because
Yes.
so Angela Rayner said at the start of the bill that in her view this bill would not have the effect of reducing the level of environmental protection provided for by an existing environmental law, and that's it's an interesting statement. It needs to be unpicked, and people will have different views, but there are probably losers and winners in this system.
Yeah.
And
Yeah.
you know, I would say it's quite a strong assertion she's made, given that we don't have the strict tests anymore associated with the European site protection. Obviously, the legislation is not mentioning, it's silent on many of the aspects of the protection we're used to for those sites. And the case law that applies will no longer be relevant, because once under the Withdrawal Act, once the legislation domestically is modified, the case law from the old system falls away. So we're now left with a likely outweighing test, which is the one I've talked about earlier, and a kind of reliance on natural England to interpret the powers that it has in the way that it will, and we don't know how they are going to interpret those powers. I mean,
Absolutely.
we know the secondary legislation and guidance is going to be forthcoming, which will hopefully fill in some gaps. But some of the concerns we have are about the robustness of the assessment that underpins the environmental delivery plan.
Yep.
I mean, if a delivery plan is made pretty quickly, there will be not that much time to get data to underpin an assessment. Indeed, legislation doesn't even require specific assessment. It requires identification of impacts, which is not quite the same thing. It also obviously also the geographical scale of these plans could be quite large, and so query how much data is really reasonable to obtain. Also, as Richard's already said, the mitigation hierarchy, there's no mention of it in this bill. Now, that doesn't mean to say Natural England might choose to use it. I mean, the NPPF is there with a mitigation hierarchy. That's the National Planning Policy Framework. Natural England would be, I think, not sensible to ignore it, because then when local planning authorities come to determine planning applications, they'll want to consider that. So if Natural England hasn't in its environmental delivery plan, that's going to be a bit confusing. So, I mean, there's just so many unknowns and so many silences. Another one I know you're concerned about, Richard, is the silence on the issue of, that the developers pay and go, but there's no necessary link to the time frame of delivery of the compensation measures.
So for me, a big test here is whether there will be unmitigated impacts on European sites. Okay, that's going to be a big test here. So that is where, for example, with nutrients, developments are occupied. So putting nutrients into the system before the mitigation under the delivery plan is in place to mitigate for that. Will that happen? Well, We don't know. There are powers under the bill that would allow Natural England to be able to propose conditions, so that it could be a no occupation condition. But that's and in considering that, the local planning authority has to take into account this duty to cooperate, but doesn't necessarily need to take that into account. So
No.
what
And
happens in those situations?
and obviously developers want to pay and go. They don't want an
Yeah,
occupation
exactly
condition
right.
saying you can't build until you can't occupy until your nutrients mitigation. I mean, the whole point of this is to remove that kind of block. So I suspect
Otherwise, what's the benefit?
yeah, so I suspect that won't happen. So there is, there is a question mark really over whether there will be a temporal gap between impacts and conservation measures. I mean, a couple of other things which we're worried about are, I mean, it's the fact that I suppose that when you look at the levy, I did a post about this the other day actually. When you look at the levy that has to be charged, although the overall objective is my likely outweighing of impacts test, when you actually look at how Natural England charges the levy and what it must take account of when looking at that levy, it takes account of two things which rather undermine potentially any restoration. They are that when setting the levy, they should look at the environmental impacts of the development and whether they're offset, but not consider, it seems, there's no requirement for them to consider any restoration or positive net gain. And the second thing is that there is a viability test. So the levy must not make development unviable. So
Yeah,
I mean,
if those nature conservation measures are too expensive, then that's a problem. And so what we end up with then is not a polluter pays principle, but a polluter pays, but only if it's not too expensive principle. And that's a difference.
Yeah. So I mean, those are some of the concerns about the environment. Let's move on to developers, Richard.
Yeah, absolutely. So what does this mean for developers then?
Well, I mean, I think developers will probably see this positively. They can pay and go is the objective. It's a simpler way of dealing with commonly encountered environmental problems, like nutrient neutrality. And as we said in our last webinar, and hopefully that's Katie's going to put that on the chat, the link, if you haven't seen it. We don't think this was necessarily the way to go to actually deliver an easier route for developers. We think it could have been done through incentivizing the private markets and the way that we've seen that develop over the last few years. But nevertheless, the system that is being proposed is potentially more easy for developers to deal with. They won't, for example, have to worry about whether they can obtain credits on the market in their area, or whether
Well, that's a real concern, isn't it? I mean, that's something that the House Builders Federation said in the Fry case. That was a case concerning nutrient neutrality in Somerset and the impacts of that. And they said in their submissions in the High Court in that judgment, in that case, well, look, there's bottlenecks here. There's housing being held up because there aren't enough nutrient credits available in the system for them to rely on. A lot has been done to address that supply. And a lot of the reason for the delays is getting those schemes secured. But in any case, what this does is that it ensures there's supply, because if you're covered by these plans, then you can just carry on.
Yeah, that's right. On the other hand, it's going to be complicated for developers to get their heads around.
Absolutely right.
You saw Richard's diagram, which he spent ages trying to simplify for you all, but it's still quite complicated. So developers,
and you have to have the mental gymnastics of dealing between one set of tests and another set of tests, and two different type regimes essentially in parallel.
Yeah, so one environmental impact you might be having might be within the levy, you opt in, or perhaps you choose to opt out, and the other one you don't have the option of opting in because there isn't an environmental development plan covering it. So is it really going to quicken things? Don't know. It depends how many environmental delivery plans there are. Also, other environmental regimes that developers deal with will still need compliance, such as EIA environmental impact assessment, water framework,
biodiversity net gain,
and any requirements that come through from planning policy, whether that's local or national planning policy. So windfall development will be almost certainly outside an environmental delivery plan, because by its very nature no one can anticipate it's coming. So I mean, it's also a question mark over whether when developers need a separate consent for some kind of environmental discharge or environmental, permit, let's say, or abstraction license. I'm not clear on whether the old system is disapplied for that. I don't think it is. It's a bit unclear. So, you might get your planning permission through the levy, and then you might still have to deal with impacts from your environmental permit in the old way. It's something that is not clear from the bill, I think.
Yeah.
So, another thing, Richard, is that lots of developers want to mitigate their impacts because it makes sense from an engineering or project-based system to do that. Or maybe they're willing to
Yes.
the time of year when they will have no impacts on the local nature reserve or whatever it is. Now, I mean, at the moment, we're not seeing how the developers' mitigation will feed into this. So,
Exactly right. Or
yeah,
there may be mitigation schemes out there already selling nutrient credits where that if you buy the credits that you need, you've unlocked your development. Okay, but
yeah,
here you're relying on this whole edifice of a
yeah,
scheme being provided in order for you to do that.
yeah.
And I know from the developers I speak to, the thing they like least is being boxed in. Okay, and here, if you opt in, then you're on this roller coaster. You can't get off this ride once you've opted in. But also,
Yeah.
you could be mandated to do it too. And again, that being boxed in and not being able to rely on other methods to try and more quickly and more deftly unlock your development, that's a consideration.
Finally,
Okay.
Natural England then. What do you think
Yes.
about that?
So this is going to be, so I think Natural England are going to look gratefully, I think, on another potentially large and stable source of income over and above the ever-changing grant and aid funding from government. I mean, this nature restoration piggy bank that's going to be created is going to look attractive. I mean, when I was at Natural England, when I started working there, the budget back in 2009 was about 265 million pounds, and then by 2019, so that was back in 2009, 2008, 2009, and by 2019 it was 85.6 million. So savage cuts due to changing political winds. Since then, Natural England's budget's increased slightly, but again, now it's under pressure and it's going to be losing staff. So having a source of income which is outside of grant and aid given by government will be seen as attractive, and that's would also be seen as attractive as giving it not just the funding but also the powers to go about bring about large, joined up, coherent landscape scale nature schemes. Again, that's what Tony Juniper was saying yesterday at the same conference on this. That's an attractive thing. Also, arguably, it allows Natural England to focus its attention and its resources on one overarching plan rather than multiple separate planning applications or species license applications, so diffusing its resources. Here it can put it all together and deal it with in one unified way. And there's an argument in favor of that. But on the downside, my God, is this going to require a huge amount of resources
Well,
to be
yeah.
able to do this?
I mean, this is it, isn't it? It's either going to require a huge amount of resource to do it properly, or maybe the temptation will be to do fairly high level environmental development plans, which can be more quickly issued,
Yeah,
but they will lack the underpinning of information and the credibility that I think many people on this call would want to see. So
yeah,
I think we don't know which way it's going to go. There will be pressure, of course, on Natural England to deliver environmental delivery plans once this bill has been enacted, assuming it is. And I will just stress, I should have said this at the start, this is a bill, okay? We've got a number of readings to go through before we end up with an act. And there will be, of course, amendments made. So we can't
yeah.
take this webinar, I should say, as a sort of the last word at all. But no, I mean, I think Natural England is going to have to rely on partners to assist it in delivery of the conservation measures. I just want to make sure, I would like to see a mechanism by which that can happen to support all of those involved in the private nature markets enterprises that we've seen develop in
That's
the
it.
last 3 years, who have poured their hearts and souls into developing schemes, in
Yeah.
good faith, and whose rug and under whose feet these rugs are being pulled at the moment,
Yeah.
making them really concerned. And you know, we need to find a way, if this is going to go ahead, of Natural England using those markets and those private enterprises to deliver what's needed, as
Yeah.
well as potentially further schemes that they may wish to bring on
Because at the
board.
moment, developers are paying for the cost of the conservation measures provided through these schemes, but through this, they'll be paying for the bureaucracy as well as the conservation measures. You know, there's an additional cost there.
Yeah. Okay, well, thanks, Richard. I think we'll hand over to Rob now. Oh no, I'm sorry. We were just going to say, yeah, we forgot. If you'd like to see the old webinar, which was really looking at whether we could do this in a different way, that's it. That's the link, and I think it's been put in the chat.
And we explore some of these themes in that, so please do check that out. But we'll hand over now to Robert.
Yeah.
Good morning, everybody. I'm Robert Bruce. I'm a partner in the planning team at Freese, and I'm going to cover the other proposed changes in the bill relating to planning matters. So today I'm going to cover these topics: the main objectives, the top 5 changes, and will the changes work? So turning to the main objectives, I think this is fairly well publicized. There's really 2: deliver 1.5 million homes in England and 150 planning decisions on major infrastructure by the end of this Parliament. And you can see on your screen some comments from the media on those matters there. So just turning to the top 5 changes, I'm going to cover those matters on the screen, as you can see them there. And the first one's planning committee reforms. So this is really about making more decisions by officers. There's going to be a national scheme of delegation to council officers. That'll be set out in regulations. Those regulations will set out how decisions will be made by council officers and which ones, or by committee, the size and composition of committees, the government favouring smaller committees, and mandatory council member training. So a training certificate will be required before council members will be able to sit on a planning committee. And I think we see this throughout the legislation, actually. There's a philosophical debate, really, between the Conservative Party and the Labour Party. And on this one, I think the debate's around what level of elected politician involvement is appropriate in a democracy. So it's really an issue of democracy versus getting things done. And I think the Conservative government really favouring more political involvement. I think a key question here is, will council officers be prepared to determine applications against senior council member wishes? I think there's real doubt about that, particularly if a matter is controversial. I think the senior officers are likely to follow what the senior council members want. That's my hunch on it, in many cases anyway. Turning to planning fees, the problems demonstrated by an estimated 362 million shortfall nationally for planning application services. So the Secretary of State's going to be given a power to make regulations for councils and the Mayor of London to set their own fees. Planning applications obviously would be included, but also this could include other planning services. I mean, question, might they include enforcement, for example? Recovery will be allowed up to the full costs, and all fees are to be ring-fenced for the relevant planning function. That's something, I think it's a good idea, actually. I think it's something a lot of people have been calling for a long time, because, of course, councils are under pressure, so they're siphoning a lot of the planning fees to frontline services. This is likely to have an impact on council taxes and rates, so could be an issue for council leaders, for example. And the government believes cost recovery will lead to improved performance. And again, I think there's another example of the Conservatives versus Labour philosophical debate, because I was at a previous meeting with the Conservative government. A senior officer from the department was there, and he was clearly saying that the Conservative MP or Secretary of State didn't view throwing more money at a problem as solving the problem. So there's a question: will it solve the problem? I think most people recognise there's a chronic underfunding. I think that could be helped by ring-fencing the funds, but there's probably a need for more funds. But I do agree that I don't think we should necessarily think that that will necessarily solve the problem, but it will certainly be a big help, I think. Spatial development strategies, generally that's only in London at the present time. So SDSs will be part of the equation, but it's important to recognize that this bill is not the only solution here, because it's really about the things that have to be introduced by primary legislation. So a lot of other changes can be made outside of that, and we've seen that through the reintroduction of council housing targets and MPPF changes, and I think they're the other two big ones. So the introduction of strategic planning is actually a return to the 2004 type system. So again, this is the philosophical debate, Conservatives versus Labour, because Labour previously introduced them in 2004. They were called the regional spatial strategies. They were then removed by the Conservatives in 2010. So this is really just a reintroduction of what the Conservatives previously removed. They're going to be strategic documents. So regional spatial strategies are probably a good indication of what they'll be. They'll be setting housing numbers and distributions, not allocating sites. So that'll be at the local plan level. Generally, they're going to be produced by combined authorities. That's the Manchester Combined Authority type example. They'll be tested at public examination, and they'll be submitted to the Secretary of State before adoption. So the Secretary of State will be able to check, do these plans conform with national policy and the like. They will be part of the development plan once adopted. So they'll be considered alongside local plans, for example. And local plans will need to be in general conformity with them. If London is an example, the question is strategic planning delivering in London? Well, I think if you look, I think there's clearly a severe under provision of housing in London. So there's a potential indicator there. This doesn't necessarily solve the problem, but I do think reintroducing with housing targets, that is something that will be helpful. So just turning to major infrastructure, some of the key changes here are national policy statements to be reviewed at least every 5 years. They set the basis for NSIP, if I can call them NSIP, Nationally Significant Infrastructure Projects. They set the basis for determining those, because they have to be determined in accordance with those national policy statements, so they are important. I think a very helpful change is the flexibility to give the Secretary of State power to direct projects out of the NSIP regime. So they go back to being determined by planning application, for example, because there's been a number of examples I've seen where energy projects have been submitted just under the NSIP threshold to get them into a planning application, when the promoter really wanted something a bit bigger, but they didn't want the NSIP process. So I think that's a helpful change. There'll be NSIP consultation reports that will be shorter. On judicial reviews, the government's following Lord Banner Casey's review to remove the permission stage on judicial reviews, and also remove the ability to appeal cases to the Court of Appeal that are determined to be totally without merit at the permission stage. When I say permission stage, on judicial review, there's two stages. You first apply for permission to see whether you have a reasonably arguable case. If you get through that first hurdle, then you go on to consider the full judicial review in the court. So that's dealing with those permission stages. Actually, on the totally without merit issue, I don't think that's going to create a big difference in practice. I've only ever seen one case fall within the totally without merit category. That means it's got absolutely hopeless, not possibly arguable at all. And I've only seen one fall in that category, and judges are very reluctant to determine a case to be, fall under that threshold. So I don't think that will make a big difference, but it's a change.
Hopefully it wasn't your case, Rob.
No, we were acting for the defendant on that one. So, and on electricity, I think there's a number of changes in electricity. I'm not going through all of those today. I'm just going through the main changes, but I think it is worth mentioning changes to the grid connections decisions to consider the priority of the applications for grid connection, not just the first come first serve basis, because that is a real problem for energy projects. Getting the grid connection, sometimes there can be years of delay, so I think that's very helpful. Just turning to CPOs, these were previously the power, to remove hope value was previously introduced by the Conservative government. The proposal was to extend that Hope value is the prospect of obtaining planning permission, but that obviously changes value significantly. However, I would say, and this is where I think there's a real problem, is hope value is part of the actual value in the commercial world. If a site maybe is agricultural but it's got the hope value prospect of obtaining planning permission for housing, that's an entirely different valued site to the agricultural value. So I think there's problems with this, but they're expanding that power. So I've noted possible human rights and so on. And there's a number of proposals, as you can see on the screen, for speeding up CPOs. Big question is, will the changes work? It's interesting to look at some opinions. Steve Barclay, MP, concerned about destroying farming in the countryside. Victoria Spratt there, a journalist in this area, welcoming the changes, I think, but saying they're not going to be anywhere enough to meet the pledged 1.5 million homes. I mean, I think we'll come on to that, but bear in mind that the bill is not the only changes in play here. I think predictable concerns from councils and the local government association. Very concerned about councillors being sidelined, being removed from their democratic role, and it being a backbone of the English system. British Property Association welcoming the changes, but noting adequate resourcing is very important, and I think we probably all agree with that. Victoria Hills with similar sentiment, and the Home Builders Federation thinking that they will help to tackle the crisis and will accelerate output if implemented. Just turning on to our thoughts on this. So I come back to the point, the bill's a part of a package of measures, it's not to be viewed in isolation. I think one always goes to the historical experience on this. While England has not built the required housing volume since 1960s, so I think doubling the homes built in this parliament is very unlikely. Even if the changes are sufficient, and there's the potential doubt around that, I think they'll take longer to have substantial effect. So I don't think that's going to happen this parliament. On infrastructure, again, looking at this historical context, there's been 237 development consent order applications for the NSIPs and 145 decisions since 2008. So I think it's very unlikely they're going to have 150 planning decisions this parliament on truly major infrastructure. Bear in mind, though, that major infrastructure can be approved outside the DCO process, but that gives you an indication on it. So at a quick canter, that's the changes on the other planning matters and our thoughts on them. I'm going to hand over to Katie to take us through any questions. Thanks.
It looks like we've had a lot of questions.
Yes.
Yes, indeed. We've had quite a few questions. I'll start with a couple of the planning questions, if that's all right, Rob, and stick with you, and then we'll move on to some of the more environmental questions. So first off, what risks do the proposed CPO powers represent for landowners who have active option or promotion agreements?
Very substantial, actually. As I say, those changes already exist. The changes are to extend the powers, but the ability to remove hope value where you fall under the categories of affordable housing, education, and health, that's when a direction can be made to disapply the hope value, would be very substantial. Because if you've got a site that's plumb for development, irrespective of any proposal the government's putting forward, they can remove your hope value, the prospect of obtaining planning permission, so you'd be left with agricultural land value, for example, if it's agriculture. So that, I do think that's problematic, because in the commercial world, as I pointed out, the prospect of obtaining planning permission is part of the actual value. One shouldn't see that as a mere hope, if I can put it that way.
And kind of following on from that, are there any sites or kind of categories of sites that you think might be key targets for these new CPO powers?
I think, well, the categories that they apply to are where the government can make a direction to disapply the hope value is if it's a proposed education, health, or affordable housing. So it's where those might be located. I don't think there's any prescription around, you know, what type of existing sites that might be. I think it comes to where those facilities might be appropriately located. But there is, you know, I have seen in practice issues around if it's a regeneration project, for example, where you have a major developer doing the large part of the site, but there's a few smaller landowners who own smaller holdings. I have seen problems with the major developers putting, you know, the lower value uses onto the other landowners' sites because they can't do a commercial deal, and you could be exposed there because often the council's working very closely with the master developer, so you could be exposed to having the low value use put onto your land, and then the developer or the council using the council's CPO powers to get that land cheaper.
Thank you. I think I'll move on to a couple of general kind of practical questions about the passing of this bill and how that would work. So there have been a few questions about whether there's any process by which people could raise concerns about this bill, particularly in advance of the second reading, which will be on Monday, March 24th, and kind of how people would go about doing that and holding the government to account for some of the perceived issues that have been raised here.
Well, I mean, I guess you could do that in normal ways by getting in contact with your MP, but also I'm sure there'll be ENGOs who are interested in raising their concerns as well. So, or other elements of civil society which lobby government.
I saw a post from SAIM, that's the Chartered Institute of Ecological and Environmental Management, yesterday, and they were inviting anyone with concerns to speak to their MPs. So I think that's what you need to do. Yeah.
I think the other thing you could do is, because in my experience, individual landowners, when you've got a bill going through Parliament like this, carry limited weight. So you could look to try and team up with more powerful bodies, sort of, you know, maybe countryside organizations or someone who has more sway with a lot of members, that can influence things.
Yeah.
And then the other main one was sort of focusing on how long do you think it will be before EDPs are up and running? And kind of following on from that, does that mean that ecologists need to be concerned about the kind of ending of on-site ecology assessments?
Yeah, I mean, I do feel concerned about the ecological sector. I mean, the first EDP will probably be things which the ecologists are not that involved in as much as others. So we think it'll be nutrients, don't we, Richard?
Surely it must be, right?
And we think that will probably be progressed, I don't know, during the next, you know, after the act becomes an act.
Yes, you can imagine some work being done in parallel with it, but you'd have to wait until the second legislation came through anyway, wouldn't you?
Yeah. I mean, I think what ecologists have got to do is focus on the fact that there will then be I think a much longer delay probably for other EDPs to come forward, and I mean, there will always be the need to consider impacts which aren't covered by EDPs, and also, you know, helping developers understand whether they should pay the levy or actually whether it's cheaper to go the old route. So there's going to always be a role for ecologists in helping developers decipher this route, apart from the fact that there is still going to be the need for, you know, compliance with local plans and what their requirements are. BNG, there's going to be EIA still. So it does potentially threaten ecologists, but on the other hand, you know, I think you've all ridden the storm of, for example, Great Crested Newt district licensing, and that, you know, you're all still up and running and busy doing now biodiversity gain assessments. So, you know, I think
and this will probably operate like that, won't it? Where you know, a consultant ecologist is talking to the developer and they're saying, well, look, you know, you could go down this route or this route, because in this area it's covered by an environmental delivery plan, just like, you know, with DLL now is you could go and get a district level license, or you can go and get your individual license. Here are the pros and cons. It'd be similar to that, I imagine, that kind of sort of advice on options.
I mean, it's like any business. You've got to look for the opportunities when faced with changes, and that's really the message. I think there'll be work. There's also going to need to be a lot of subcontracting by Natural England to people to try and deliver these plans, we think. So and the measures that are required to be delivered to comply with the plan. So, you know, there's going to be work there as well.
And a couple of questions about how the EDPs will actually work. So there's been a few questions about how this will affect which kind of housing developments can opt in and opt out, and whether this is actually really a piece of legislation mostly aimed at major infrastructure projects, or whether you can see it actually really being useful to facilitate kind of smaller developments or housing development.
I think it definitely is aimed at a whole swathe of developments. I don't think there's any suggestion it's only aimed at
That's for sure.
projects. I mean, I think infrastructure projects could benefit because there might be a specific environmental delivery plan written for it, and then that might provide a pay and go system for that infrastructure development. But you know,
where this works best is where there's lots of development, all with the same sort of impacts, which all could be calculated in the same way, and with a suite of measures to address those impacts which are agreed. So nutrient neutrality is the perfect thing. And so you'd have a environmental delivery plan for a particular district that has nutrient neutrality as an issue, and this will be the premier option of how you address that. That's how this is going to be promoted.
And then obviously EDPs will the scale of EDPs is quite a concern. So how might EDPs take account of irreplaceable habitats or very specific habitats or species in one area?
Well, I actually read something about that this morning. The government has posted some information about this new system, and they've said that if there were, for example, irreplaceable habitats, then that would not be suitable for an EDP, for example. So there may well be particularly rare habitats or even species where an EDP just won't be available, but who knows what they are exactly. That will be a question for Natural England. And you know, I think one of the concerns, we haven't really touched on this yet, but one of the concerns really about the system is that whilst there is a consultation process that Natural England must undergo, the ability to challenge these environmental delivery plans is really quite limited. It's specifically limited to judicial review within 6 weeks. And, you know, thereafter, people who are concerned about the environment wouldn't have much of a say. The levies would be charged to developers and they could appeal those, but there's not much more that can be done. So, you know.
And there are provisions in here, like clause 50, paragraph 4, where an identified environmental impact or protected feature, protected site, and Natural considers it appropriate, then the conservation measures might not directly address that feature, but address that feature in a different location. So, you know, there could be some, you know, quite different in the poach. There's quite a lot of flexibility here for how Natural is going to apply this.
We're coming to the end now, Katie. I don't know. Are there an awful lot more questions? Because if there are, we were talking about the possibility of running a half-hour Q&A session separate to this. What do you think?
I think there are a lot of questions. I think a lot are quite specific and relate to kind of how the bill was going to work in conjunction with other things, which might maybe benefit for waiting for further guidance and secondary legislation. But there are certainly plenty of questions that have come through. So.
Okay.
I think that's just a general situation, isn't it, Penny? There's a lot of question marks over how this is going to operate. A lot of lack of information about it.
Yeah. Okay. So I think we might well convene a half-hour session, not next week, the week after, to where the only people that those of you who are on the call now would be invited if you wanted to attend, and we would go through some of the further questions. Obviously, we can't really answer everything, but in a half hour we can pick out what we think are the most important. So we'll be in touch over that for the people who are registered on the call today. But I think beyond that, I think we will just wrap up now. So thank you very much to everyone who
thank you,
and for all your engagement and for your questions. Hope you found it useful. We will be uploading this onto a YouTube video in due course. Probably that'll take a couple of days, so then you can share it with your colleagues if they want to listen to it. And of course, I'm going to make a little plug now. If you do want in-depth discussion with either of us and any of us on the bill, we're always willing to do that. But it would sort of, I suppose, we could do some training for you on a bespoke basis if you wanted that. So that's something to bear in mind as well. Okay, thanks very much, everyone. See you soon.